Because that would be my last question to you. The many ways of accessing the court, and which of them you think should be tweaked a bit?
Which one should be?
Tweaked. Which one shouldn't remain that way, if there's one?
My lady, if I understand the question, you're asking about the jurisdiction of the Supreme Court. The Supreme Court has original jurisdiction, first to determine disputes regarding presidential elections. It has jurisdiction to hear appeals from the Court of Appeal, other courts and the tribunals. It has jurisdiction to give advisory opinion.
Other courts and tribunals, my lord?
That's what my reading of Article 163 says.
Which tribunals, my lord?
And the tribunal.
Sorry, which tribunals, my lord?
They call local, but I believe there's only one tribunal, which I was going to come to, that it has a jurisdiction over advisory opinion, and then, of course, to deal with issues of declaration of state of emergency, and finally, decisions of a tribunal investigating the conduct of a judge. Which one it shouldn't? I think all of them Kenyans thought were useful areas to take to the court, being an apex court. And other than the one on declaration of state of emergency, the court has been able to express itself in all of them. The one on tribunal, I think there has only been one of Judge Mutava. Thank you, my lady.
Yes, my lord. There's another one pending, and I'm sure there will be many more. My lord, that will be it from me. I wish you well, my brother.
Thank you. Thank you, my lady.
Thank you very much, Acting CJ. I will now request Honorable Judge Wasame to ask some questions.
Thank you, Chair, Professor. My Lord, welcome once again.
Thank you.
My Lord, there has been a lot of murmurs around the court that it has not lived to its billing, that the court is taking up unnecessary cases, and the jurisprudence that is coming out from that court, it's not, it's somewhat contradictory, and sometimes unnecessary. You have been in the Court of Appeal now almost 5 or 6 years. You have been the president of the Court of Appeal. You have done extremely well for the court. For the last 3 years, you have been the head. Now that you will be the mono, one thing you will do to change that perception about the court.
Thank you, my lord. Yes, the perceptions are really just perceptions, because if you read the decisions from the Supreme Court, and this opportunity appearing before this commission twice has given me an opportunity to read a lot of decisions from that court. I cannot agree with those criticisms. Those cases are very well researched, well reasoned. There may be one or two which cannot be a basis to make a general blanket assumption that everything is wrong. if you honor me with this position and I go to that court, to reduce this perception, and I think the court also speaks to this in its strategic plan, is to reach out, to talk to wananchi, to explain to the consumers of their services of what they do, how they arrive at those decisions. I also agree, and it is in their strategic plan, to involve reviews from the academia, reviews from the lawyers, and this way those perceptions will be reduced, if not completely eliminated.
Now that you have talked about what you do, one stakeholder who appeared before us, who is an advocate, told us, and I quote, "It is difficult to advise clients on any matter pending before the Supreme Court." What is your view?
That presupposes that the decisions of the Supreme Court are contradictory, and therefore the advocate is not able to tell how the client's case may proceed. Again, I can say, unless we have details, particulars, that I was unable to advise my client, who was an MCA, who wanted to appeal to the Supreme Court because there are contradictory decisions on that aspect of elections in that court, then it can be addressed. But just saying generally that I'm not able because there are contradictory decisions, it doesn't really help. You'll recall in our court, whenever we have this, and they're there, where we have contradicted ourselves, we admit that here we have, because advocates have either drawn our attention to them by asking the president to constitute a 5-judge bench to resolve the conflicting decisions. I really would not say much regarding that without details of those contradictions, my lord.
We were also informed, my lord, that, and this was supported with that position taken by the stakeholder, and he said, a matter before the Electoral Commission is the validity or eligibility of a candidate to contest or be nominated. That is before the IEBC, before the High Court, before the Court of Appeal. But when it reaches the Supreme Court, that eligibility question is changed to something else. Any views?
Thank you, my lord. Again, I'm guessing you are referring to the Wajir gubernatorial.
I'm not referring to any matter.
Okay.
That's what we were told.
Yes, but I can deduce. That's one area that perhaps is difficult to reconcile. And as I said last time, that there are criticisms. Some have valid basis, some don't have. Some are just generalized, some may be particularized, and that the court needs 10 years later to introspect, to reevaluate its performance going forward. And some of these areas, like the one you just said, is important, because then the court being one whose decisions bind on the courts below it must be seen to have a very clear instructions to the courts below by way of president.
Okay. Again, and this is my last question, my lord. One area which you have done very well as the President of the Court of Appeal is to ensure that electoral disputes are decided within the timelines, within the 6-month period. From my own research, if you get the opportunity, God willing, I have seen some matters taking almost 1 year, some others taking 9 months before the Supreme Court and before they are decided. I don't know how you will change and ensure that if a magistrate has decided a matter within 6 months, a judge of the High Court has decided within maybe 4 months or 3 months, Court of Appeal has decided the matter within 2 or 3 months, and the Supreme Court is taking a period more than 6 months, although there is no time restriction on the Supreme Court, and this is the apex court. What kind of example would you ensure that the court follows, such that timelines are clearly respected, such that there is nobody complaining about the court in terms of delaying hearing of electoral disputes?
From the magistrates' courts all the way to the Supreme Court with regard to presidential elections, there are timelines. And I must say that the courts have done exceptionally well in keeping to those timelines all the way. And this is perhaps attributable to the training that is conducted throughout the period preceding elections and even after the debriefs that follow, where we discuss jurisprudential issues, where we discuss these timelines. And so whereas all courts were able to render their decisions within those timelines, as you have correctly pointed out, the Supreme Court doesn't have timelines in election petitions other than those of presidential election. They may go beyond 6 months. I do not know of any case. There's only one case that, perhaps two, that have bothered me. I think the Waibera case, the thicker one, which has gone back and forth. It's going to 4 years after elections, and it's still pending somewhere. It's gone back and forth. I haven't read the history why it is still pending. And the one of Honorable Karua. I do not think that for those two cases you can blame the Supreme Court for going beyond the period, because for Honorable Karua, the back and forth between the Court of Appeal and the High Court consumed all the 6 months. And so I think through this training, where we as a court sit together, in the Court of Appeal, identifying all the election appeals, applications, and they are all given priority. The same can be used in the Supreme Court as they come. You put aside everything else and concentrate on them. That way, we shall be able to meet the deadline. Although there is no timelines for the Supreme Court, wherever they are seized of matters to do with elections, I think it should also follow suit that it ought to be 6 months for them.
Okay. Now that you have mentioned Mother Karua, let me have the last bite. I think both of us were involved in the Mother Karua, and the first Mother Karua case. And you can remember the judge in the High Court rendered that ruling, striking out the petition, I think within 2 months. Mother Karua filed her appeal in the Court of Appeal, I think in October or November, before the matter could be listed it took almost 3 months. It took almost 3 months in the registry. So it cannot be said Mother Karua now consumed the 6 months, because the 6 months in the High Court and the 6 months in the Court of Appeal. Because if the court delayed her case before listing it for 2 months, and there were several letters we read in the file, and the matter now was decided that we are folding our hands because the 6 months period is over. This is a case where the litigant, who is aggrieved by the outcome of Kirinyaga elections, was concerned, and that he did not use cumulatively 6 months, both in the High Court and in the Court of Appeal. What would be a view now that there is an indictment from the East African Court?
I didn't blame Honorable Karua for the time consumed. I actually admitted it was the courts. If in our court alone we took 3 months of somebody 6 months, that's an indictment on us. And so my view is really the same thing, that we must give priority to matters that have timelines. Very true, me and you had the first appeal where we overturned the striking out. Even as we sent the matter back to the High Court, remember the debate between us took nearly 2 days, whether there was enough time for the High Court to hear witnesses and render a decision within perhaps maybe 6 days left. But we said there was still time. Let them go and see if they can do it within those days. It was a tall order. And so really, we must take the blame for the delay in hearing this petition and the appeal. Thank you.
Thank you very much, my Lord. I wish you well.
Thank you, my Lord.
Thank you, Judge Wasame. Thank you, Your Honor. Judge Majaja, it's your turn to engage the judge.
Yes, thank you, Chair. Once again, good morning, my Lord. I just want to follow up on 2 issues from the discussions you had with my colleagues. The issue of MCA appeals, you mentioned something, but you didn't quite complete what the idea you were saying. What is the legal position regarding MCA appeals to the Supreme Court?
It has now, I was saying that, excuse me, with regard to the question that I was asked, that counsel is not able to advise client regarding decisions of the Supreme Court, and I just said as an example that unless that client is asking specific questions that I want to appeal to the Supreme Court as an MCA and the decisions are conflicting, the Supreme Court has now settled this matter. In the case of Tumaini, where the Supreme Court has said that these things must end at the High Court, and that is the position.
Okay. Now, can you now look at that decision vis-a-vis the position of the the Supreme Court in the other election petitions, where they are saying that because the Elections Act is a normative derivative of the Constitution, a party in an election petition can go all the way up to the Supreme Court? Don't you think there is a contradiction, and how would you reconcile it in view of the latest decision?
The MCA disputes start from the magistrates' court, the appeal to the High Court. If they were to have a second appeal, it would be to the Court of Appeal, and then to the, so those are too many levels, which other electoral contests do not have. Normative derivative, was a creation in Munya 1, where